Let's dive straight into this debate. Joining me on India First is Manish Tiwari, Member of Parliament from Chandigarh, former Union Minister, Information and Broadcasting, former Member of Parliament from Ludhiana and Anandpur Sahib. You're a lawyer yourself, a lawyer par excellence who's authored 4 books. Sir, welcome on India First.
Thank you very much, Gaurav. Thank you for inviting me.
Sir, you're not only a multi-term MP, you're a leading lawyer. You understand the constitutional jurisprudence very well. You've called this bill squarely destructive. Why so, sir? When the Union Home Minister asks, should anyone run the government from jail, either get bail within 30 days or take over whenever you get bail? Governments cannot be run from prison.
Gaurav, that's a very malicious way of even framing the debate for the Home Minister. And allow me to explain and contextualize why. Going back to the times of the ancient Greeks and the ancient Romans, when the fundamental postulates of common law started evolving, there is one grundnorm or basic postulate. That is, you are innocent until proven guilty. These constitutional amendments, or this constitutional amendment and consequential amendments in the Union Territories Act and the Jammu and Kashmir Organization Act, stands that fundamental maxim on its head. Essentially, it holds you to be guilty without even as much as charges being framed against you. That is number one. Number two, Article 21 of the Constitution of India guarantees that you will not be deprived of your life and liberty except in accordance with the procedure laid down by law. This is the due process clause. So therefore, under those circumstances, the registration of an FIR, an arrest, if required, investigation, filing of a charge sheet, and even framing of charges is absolutely no evidence of any culpability or guilt. In fact, you only plead not guilty once charges are framed against you.
Yes.
That's when the trial formally commences. So what this constitutional amendment is doing is standing the fundamental jurisprudence of Article 21 on its head. Number three, there is a collective responsibility which the cabinet has to the legislature. So therefore, under those circumstances, the constitutional scheme as it is structured does not contemplate that the collective responsibility of the Council of Ministers lies to anybody except the legislature. In this particular case, the whole concept of collective responsibility, has been turned on its head.
Okay.
And then all constitutional safeguards with regard to due process, with regard to disqualification are only after conviction, and that too by the highest court of the land. Everything has been upturned. And you cannot enforce morality by law. And that is the experience of the 10th schedule, or the so-called anti-defection law, or the amendments which were carried out with regard to open voting for the Council of States.
But sir, shouldn't morality in public life be supreme? Point 1, point 2, and all the objections that anyone may have, and especially our honorable lawmakers, shouldn't they be debated in Parliament and in the JPC? The Home Ministers argued that elected government in Parliament can bring any bill. They can bring constitutional amendment. What objection can the opposition have in a bill being tabled on the floor of the House? Why tear it into pieces or words to that effect? And I want to ask you, sir, he says, discuss it in JPC, put it to vote, express your opinion. It's a constitutional amendment, two-third majority would be required. Why is the opposition not keen to go through that entire parliamentary process?
For this, for the simple reason, beyond the seventh schedule, Article 246, the union, state, and the concurrent list, lies the basic structure doctrine of the Indian Constitution. And the basic structure doctrine holds that there would be rule of law. And rule of law, or implicit or explicit in that rule of law, or the foundation of that rule of law, is the presumption of innocence.
Yes.
Until proven guilty in a court of law. The government cannot bring legislation which hits at the basic structure of the Constitution. Number two, democracy has been held to be a basic structure of the Constitution. And here you are actually throwing the rights of the elected representatives completely to the winds by making an investigating officer the boss of the Prime Minister of India. Try and countenance the implications of what this is. Suppose I am the chief minister of an A state,
Yes.
hypothetically speaking, and I travel to B state, and I am arrested there. I am put behind bars for 30 days. Bail is not granted. My chief ministership is gone. And let me extrapolate even further. God forbid, if you have a situation where you have a mischievous chief minister and he does the same to a prime minister. So try and imagine the implications of what you have really brought. Today you have two chief ministers of Punjab and Haryana who live in the union territory of Chandigarh, which is controlled by the central government.
Yes.
Once this constitutional amendment comes into force, which I hope it doesn't do, because it is completely egregious and unconstitutional, you will find both of them will not live in Chandigarh. One will go and live in Mohali and the other one will go and live in Panchkula.
Okay. But
So therefore, the weaponization of our law enforcement instrumentalities, both at the center and the states, is a reality, right? It is not as if you are living in a completely utopian system whereby everybody is acting in accordance with law.
But a police officer, even if he were to arrest somebody, there are courts of law at every level. A trial court, a superior court, high court, division bench, Supreme Court. There are so many avenues of grievance redressal. And is this a debate about constitutional morality and public trust? I mean, look at, it's about the Prime Minister, the Chief Minister, and the ministers. Caesar's wife should be above suspicion principle. Shouldn't that be adopted in public life? If it leads to charges and arrest, secure bail from multiple courts on law. And sir, you as a lawmaker in Parliament who understands law so well, you can bring in systems where safeguards and checks and balances can be inbuilt into this law.
I'm sorry, Gaurav, this constitutional amendment is extremely mischievous, but from purely a constitutional standpoint, anything which stands the presumption of innocence until proven guilty on its head and then triggers action based upon that is completely and absolutely unacceptable. I was giving you the example of the 10th schedule.
Yes.
You brought in the anti-defection law with all good intentions in 1985. What happened? A retail activity first became a wholesale activity, then became a supermarket, and now has become a mega mall. Have you been able to enforce constitutional morality through law with the 10th schedule? You brought in open voting in the Council of States in order to ensure that there is no cross-voting or voting does not take place for extraneous considerations. Has it really stopped people who allegedly possibly may not have the most honorable of credentials from coming into the Council of States? The answer is no. So therefore, the simple reason is constitutional morality or morality is purely a personal choice. You cannot enforce it by the rigors of law. If I feel that I should step down, if at all I have been rightly or wrongly charged or something, that's entirely my prerogative. You cannot stand the entire judicial system of the country on its head just because you want to enforce some principle of spurious or extremely dubious morality.
Okay. And how do you see the parallel that the Home Minister tried to draw between the 39th Amendment protecting President, Vice President, Speaker, and of course the Prime Minister being brought in, into that from judicial review to the 130th Amendment bill where the Prime Minister wants to bring himself under review. No insulation even for the Prime Minister, the Home Minister said.
Well, you already have the lokpal. That is why you created the lokpal. You created an institution over and above the elected political executive primarily because of such dubious reasoning. Even at that point in time, I was in a minority of one and I strongly opposed the constitution of the lokpal, primarily because I felt that you cannot have an overarching authority over and above the political executive when you have a complete investigative machinery and a judicial system which is independent of the executive. So therefore, I keep stressing that you cannot have a situation whereby because it suits you at a certain point in time or because you feel that these constitutional instrumentalities can be weaponized against your political opponents, you do it for short-term gain. The implications of these amendments are absolutely portentous and ominous, and they will reverberate beyond the tenure of all these governments. So essentially, when you sow the wind, you reap the whirlwind, and these constitutional amendments, and I've only outlined some of the implications of these amendments. If at some point in time I can chapter and verse narrate 10 more portentous implications of how if these amendments ever actually become law, what they would do to the political system.
So
You
on
see,
the charge,
eventually,
on the charge,
collective responsibility of the cabinet,
yes,
whether at the central level or the state level, is not to an investigating officer. It is to the legislatures. And here you are saying, if you are arrested, absolutely on a false charge perhaps, and you are not able to get bail for 30 days, either the chief minister will sack you or you get automatically sacked. Or if you are the chief minister, if you do not resign, you will automatically go. The same applies to the union legislature.
sir, but explain this to me. If a person arrests you wrongly, arrests a minister, chief minister or prime minister wrongly, there are multiple levels of courts of law who will go into those arrests, and if that arrest is wrong, grant bail. If not in 30 days, in 35 days, 40 days is the point the Home Minister is making. Point one.
I am sorry.
Also the point. Okay, go on, sir.
You have provided for safeguards in the Prevention of Corruption Act by inserting Section 17A, saying that without sanction you cannot register FIRs against public servants. And here you are turning that entire safeguard completely on its head by saying that you can be picked up at any point in time in possibly a false FIR. And if you are not able to secure bail in 30 days, off you go. And tomorrow, when that case goes to trial and your innocence is established, who is really going to account for the reputational damage? Okay. And over and above that, what is the dangerous precedent you are setting? The dangerous precedent you are setting is that thousands of years of jurisprudence, which says innocence is the fundamental maxim. Okay. You have to be proven guilty beyond reasonable doubt in a court of law. Okay. The moment you have a situation whereby there is an arrest and after 30 days there's a resignation, you have explicitly or implicitly turned that principle on its head.
But didn't the Honorable High Court also say exactly the same thing in reference to a chief minister, that he should ideally have resigned, but the High Court said so, that they believed he should resign on moral grounds, but there is no provision in the current law to make him do so. The Home Minister in this interview says that his party and the Prime Minister believe that no CM, Minister or PM can run the country while being in jail. When the Constitution was, debated, the makers of the Constitution did not imagine, in his words, such shamelessness, that such a chief minister would continue to operate from jail as chief minister, and that is why this amendment is required.
Well, what about the shamelessness of all those people who triggered up investigations against people who ultimately were not even charged at the end of the entire process and had to spend 2.5, 3 years in jail? Who is going to account for their reputational damage? Unfortunately, the law of torts is not developed in this country.
Yes.
Otherwise, if these investigating agencies who act in an arbitrary and malicious manner would have been slapped with damages like it happens in the United States of America and some other jurisdictions of millions and millions of dollars, all this would stop immediately. If they would be made personally culpable, that God forbid tomorrow, your investigation is found to be tardy and the person ends up getting acquitted, you will be held responsible as to why did you initiate the process in the first place. There you have given protection for actions in good faith.
So
what is the conviction rate of your agencies?
So
what is the conviction rate of your police forces? Ultimately, the difficulty in this country is the process is the punishment. So therefore, you make the process so excruciating and full of harassment that eventually, when a person gets discharged, and if he happens to be a public person, the arrest would be splashed on the front page of every newspaper and would be headlines of television channels for days to an end.
Yes.
And the acquittal would be buried in probably a little ticker running at the bottom of your screen, or maybe on the 17th page in the 28th column of some newspaper.
So, sir, should this come up in the JPC, would the Congress, in your view, go through this process? Because there are some political parties, part of the India bloc, that are indicating they will not be a part of this process at all.
If you personally ask me, that's a call which the Congress leadership has to take. But if you personally ask me, these amendments are absolutely excessive. Because experience has shown, Gaurav, as I pointed out with the 10th schedule or the open hand voting in the Council of States, that morality cannot be imposed through a legal process. Morality is absolutely an intrinsic instinct. Either you have it or you don't. And if you try and impose it from outside, you will, it'll meet the same fate what the 10th schedule has met, whereby government after government has been toppled by dubious means, where you have presiding officers who do not decide on petitions, for years to an end, terms of the assembly end. The person goes from one party to another, comes back to his original party, but the defection petition keeps is pending.
Okay.
So under those circumstances, what really are we talking about here? Eventually, ethics and morality does not come out of legal coercion. Ethics and morality comes out of an individual's sense of whether he or she feels or thinks that since they are a public person, irrespective of the fact that they may have been very horribly wronged, they would like to step aside, till the process plays itself out.
That's we see that morality in our leadership, and especially our ministers, Chief Minister and Prime Minister if this law, goes through that process. And that will remain extremely interesting to see what happens in the days and weeks ahead. But for joining me with your thoughts and your opinion on this, Manish Tiwari, former Union Minister and a lawyer par excellence.
Thank you.
Many
Thank
thanks,
you,
sir.
Gaurav. Thank you.